Number 79, Ambac Assurance Corporation v. Countrywide Home Loans.
May it please the Court, Philippe Salendi for Ambac. I'd like to reserve 2 minutes for rebuttal, if I may.
You have it?
The First Department did not follow the body of insurance law that controls this case.
Counsel, could you address what, if any, claims you now have given this Court's decision in Nomura?
Your Honor, we have all of the claims in light of the Court's decision in Nomura. First of all, it does not speak to the issues of fraud, which I'll address after the contract issues in light of your question. And secondly, the contract structure in Nomura was entirely distinct from that here. In particular, there was no insurance contract. If you look at the nature of the insurance and indemnity agreement between Ambac and Countrywide, it's plain that Ambac bargained for a very broad set of insurance warranties as laid out in Article 2. Those are conditions precedent to the liability of Ambac as provided in Article 3. And there are very sweeping remedies for breaches of those warranties as set forth in Article 5. The RMBS rights issue only comes into play in the 12th subpart of Article 2, which imports as an added protection for Ambac the rights available to the RMBS trustee. So Ambac begins with the foundational rights of an insurer and then goes above and beyond that, seeking as well the protections given to the RMBS trustee. Those rights under the sale and servicing agreement and the purchase agreement are different. They relate to what the trustee can do in terms of the loan repurchase protocol, and that's an additive benefit. So when you look at 2.01L, when it says that if Ambac exercises those rights, then to that extent it must live by those remedies. What you have is a clear separation of two different contractual structures. One, you have the insurance contract with the insurance warranties and the insurance remedies as set forth in Article 5, and then you have the distinct body of RMBS rights and remedies, which are entirely within that proviso in Section 2.01L.
Counsel, I see that, but at first when I read this, I thought that repurchase remedy certainly was geared towards the trustees' remedies, holding these securities. But if you look at, I looked at your complaint and the history that's set out there, at first when Ambac was starting to audit these loans and was seeing an incredible percentage, it seems, that were violated certain representations and warranties, you went in and took advantage of that remedy or tried to. And part of your complaint is they slow-rolled that. And I think it's actually a bad faith claim count in your complaint. So it seems you were availing yourself of that remedy, that repurchase protocol, until that process broke down. And that seemed to counteract my initial impression that that wasn't really a remedy for you.
In fact, Your Honor, the contract specifically contemplates that Ambac can exercise both its insurance remedies and its repurchase remedies. If you look at Section 5.02A of the insurance agreement, it provides that the insurer can exercise any or more of the remedies, and it specifically lists both the sale and servicing agreement and the insurance contract. So, in effect, we have alternative pathways to recovery. If
Ambac, it seems, going back to Judge Rivera's initial question, that a lot of that argument packaged differently because you are a different entity, you're not the trustee, is really, the contract can be read different ways. And the provisions may be in this section or in this section, but essentially your argument is there are certain loan level remedies and there are certain overarching transactional, or however you term them, remedies. And that to me seems like the exact argument we rejected in the moment.
I have to disagree with respect, Your Honor. What we have are insurance warranties that are categorically different. They go to the nature, for example, of Countrywide as the applicant. They relate to its operations, its financial condition,
and for
its
example, it's underwriting
policy.
It's underwriting policy, which is exactly a representation and warranty that's made as to each individual loan.
If we go through the amended complaint, there are both representations that relate to loan level misreps and representations that concern different areas of subject altogether. So for example, in sections 137 and 143 of the second amended complaint, there are references to Countrywide's representations that it held itself out to be a prudent, responsible, and financially sound lender, that it had the ability and financial wherewithal to meet commitments. And since this is a record on summary judgment, there are entire bodies of expert proof which go to the breakdown in Countrywide's risk management and internal quality controls.
Yes, but aren't you back to the Nomura problem that if you track that to what impact that has on whatever liability you may have, that still boils down to the loans are basically junk?
No, Your Honor, for two different reasons. To begin with, the damages that flow from a material breach of those insurance warranties are all claims payments under the policies, consistent with this court's prior holdings as to loss causation for insurance contracts. Secondly, the nature of the insurance warranties are effectively setting forth a threshold set of conditions that Countrywide has to satisfy, regardless of the quality of the defective loans. So these loans could be perfect. It's extremely unlikely, given the way in which, as documented by Ambac's expert reports, there were extraordinary breakdowns in the quality control within Countrywide. And yet Ambac would not have dealt with Countrywide. And not to put too fine a point on it, but Ambac would never have issued insurance to a counterparty that
Well,
was...
is that true, or you just would have assessed what premiums you would have charged?
No,
Because
no, Your
you
Honor.
would have had a better sense or an accurate representation of the risk.
Ambac would not have transacted with a fraudulent counterparty, period. It would not have transacted with a recklessly mismanaged, liability-ridden securities violator like Countrywide. And that's a gating question. That's why Ambac begins, as is typical with an applicant, it underwrites the applicant, its counterparty here. Countrywide stands behind those warranties. It has to have both the financial wherewithal to make good on any exercise of warranty breaches, and it has to be prudently managed. In effect, and you'll see this if you go through the credit review memoranda of Ambac, Ambac was led to believe that Countrywide was a blue-chip, state-of-the-art, gold standard business, and that's the basis on which it transacted. If we look at the proviso in 2.01L...
Is that true because it's a monoline insurance, or that has nothing to do with this? You just
That-
would not have entered this kind of policy agreement with this knowledge?
It has to do with the nature of the insurance contract.
Well,
and
does
that was a
that
requirement.
affect the elements that you have to prove to be successful? In other words, if you're just relying on initial material misrepresentation by Countrywide, then does that create a situation where the contract is void ab initio and you don't have to go forward then to show a justifiable reliance or anything like that?
I appreciate that question. Ambac is standing on the contract and seeking damages because it is an irrevocable contract. One key part for this, there's no question the general rule in insurance fraud, as set forth by more than a dozen cases of this court, is that the insurer need not show justifiable reliance or loss causation. But that same rule applies, as do other rules that affect property and casualty insurers, to financial guarantee insurers. The legislature mandated that in Article 6908 of the insurance law as confirmed by Oppenheimer. And the reasons, the fact that when an insurance applicant describes the subject matter to be represented, that's a factual warranty, the truth of which is a condition precedent to the liability of the insurer.
So there was
as
no
this court
contract
held.
to begin with then?
There was a contract. Ambac performed on it to the tune of $2 billion and is now properly seeking money damages from the fraudulent applicant. That's the only claim available to
So back to my,
financial guarantee insurers.
I just back to my question. Does it change the elements of what you'd have to prove?
With respect to the contract,
Right.
There is a material breach of the insurance warranty that
We have
applies
the
independently
contract
of
question,
the
we
law.
have the tort question.
Yes, we do.
Right.
With respect to the tort question, there is no requirement of justifiable reliance or a proof as to causation of loss both because of the legislative mandate which makes this court's law applicable to other insurers, applicable to Ambac, and because of the subsequent warranties confirmed by
What I don't understand is
Ambac.
how that applies to other than equitable or rescissionary relief.
Well, there is no claim for rescission. The law
I
is the
understand that
same.
because you can't make that claim.
Correct.
Okay, but all of as I see it, everything that I've seen about the statutory bases and the case law that have to do with not having to show those elements are where the relief sought is rescissory.
That's not correct, Your Honor. There are two key exceptions.
Or defending against a claim.
There are still two key exceptions. First, the First Department itself unanimously ruled in favor of the ability to bring such a money damages claim without proof of loss causation.
But we've never
correct.
held that.
That's correct. So in the instances where it's come before the courts, MBIA v. Countrywide made plain there's no loss causation requirement. And then in the analogous area of auto insurance cases, if you look at Liberty Mutual, for example.
In auto insurance cases, there's a statute, and
That's right.
There's a policy behind it, and the statute says, it basically inhibits your freedom to contract for rescission, okay? And says you can't do that. But here, you had that option. You chose, by matter of contract, not to have that relief.
2 points on that. In the auto insurance cases, there's a statutory mandate that it's irrevocable insurance. The courts then agreed, since the only remedy is one for monetary damages,
Since that was
it may be brought.
imposed, that remedy was imposed. You had no
Correct.
choice in that.
In the case of financial guarantee insurance, that is the nature of financial guarantee insurance. It is irrevocable and unconditional. So when the New York legislature said the same rules apply, all the same rules apply as to property and casualty insurers, that means necessarily that when a financial guarantee insurer brings its only remedy for fraud, which is a remedy for money damages against the dishonest applicant, that there is no different set of burdens in that proof, nor should there be. The applicant's duty of truthfulness, if anything, should be higher when the insurance is irrevocable and the insurer can't walk away. Similarly, the court's holding in Vanderveer that the insurer is harmed on day one through the fraudulent transfer of risk is even more true for irrevocable policies which can't be rescinded because there's an unbroken chain of causation from the wrongful inducement of the risk to all claims
What would the
payment.
policy reason be for us to remove different arguments, it is or it isn't, different types of insurance? What would the policy reason be for us to not hold you to a justifiable reliance standard where you have two sophisticated parties, which, as I understand it, the party writing the insurance has access to this information, and you can say, I don't need to justifiably rely. You can tell me this, and I can believe you. I'll write this policy. We'll get all these investors in. We have this complete meltdown, but I don't have to show that I justifiably relied on these representations.
It's the same policy imperative that underlies this court's settled law with respect to insurance fraud generally, which has been made applicable here. And that is, New York State affirmatively does not want insurers to conduct upfront fraud verification. Insurance is about the pooling of
But you contracted
risks.
to be able to do that here.
But Your Honor, if
And you represented,
required,
as I understand it, to your own investors that you were doing that.
what Ambac represented to its investors was that it was properly analyzing the data as provided by Countrywide.
And that meant we're
and
okay,
modeling
and you
it
believe
and
it.
analyzing it against the backdrop of the law which governs this. The reason you don't put those burdens on insurers is that since insurers pool risk, the costs will be passed on to the entire market. In effect, what you're doing is shifting costs from the dishonest applicant that here would bear all the liability, and saying instead it goes to the insurer, which drives up premiums for everyone.
Well,
In
your
addition,
premiums would be less then if you don't have to show justifiable reliance, because in essence, the insured is insuring you by making these representations. And then why do you need a due diligence access clause if you're not going to do it and you're just going to rely?
in practice, there is extraordinary due diligence done by the insurer. It is focused primarily on the counterparty itself, on the applicant, as it should be, because the applicant bears that duty of truthfulness. Again, if you shift
And
those
what
costs...
due diligence was done here that didn't reveal the pervasive fraud that was going on in Countrywide that you're now complaining about?
The record is replete with the analysis of Countrywide's operations, its financial condition, its statements as to its underwriting protocols, its very specific warranties, which this court has previously held, for example, in
But again,
DDJ.
they told us this. You told me just now that you do this due diligence at a company level. What due diligence was done at a Countrywide company level that didn't reveal this pervasive fraud at the company level?
Well, Your Honor, the nature of obtaining those warranties is precisely to augment the due diligence. So there were not just statements, but factual warranties. In addition to the factual warranties, which an insurance applicant statements always are, Ambac got this whole suite of protections in the insurance contract, plus the loan level warranties that were made to the RMBS trustee. And if I could briefly pause for a moment here, if this court decided that it would carve out a special exception for financial guarantee insurance, contrary to the mandate of the legislature, and said that entities like Ambac would have to prove justifiable reliance and loss causation, what you're doing is creating an extraordinary incentive for applicants to lie. As the court held in Ginsburg, what you create is an opportunity for the applicant to freely misrepresent the facts and still recover if the causal connection can't be traced. And this very case is a good illustration of that. Under the First Department rule, Countrywide can commit fraud, materially breach the contracts, and still get transaction insurance across every single deal.
But I guess the answer to that might be that you still have to show, you can show you justifiably relied. You don't want to have any showing, so it's not an issue. But it doesn't prevent an Ambac or another insurance company from coming in and saying they represented these things in this context and we justifiably relied on
Well,
them.
to be clear, we do believe Ambac justifiably relied, but that's not the question. The question is who bears the risk for that?
So they're
Who
really
owns it?
gambling you won't justifiably rely. if they
It's
just
no
blatantly lie to you.
gamble at all. It's a settled course of business based on who owns the duty, and it's the applicant. The reason, as this court held in American Surety, is to make sure that the entity which knows the most about the subject matter of what is to be insured
So
describes
even
it
though
exactly.
you've really taken the position, you don't have to bear this burden of relying, the reality is, the essential point you make is, you justifiably relied, and that's the law, based on their statements to you. You could do some checks of the statement, but you're not going to drill down. Am I understanding this argument?
I would say, Your Honor, that because the statements are factual warranties, as this court held in American Surety, Ambac is entitled to rely as a matter of law. There isn't a
So
separate
in other words, let
burden
me
of
just
proof.
take an example.
Yes.
They come in and they say, this is the protocol for us to confirm the risk of the loan. And they set out what their protocol is. That's what you're calling the factual assertions, what they do?
That's among the factual
Okay, so
assertions,
let me
yes.
just stop there. So then, your position is, if they say that's what they do, you don't have to then confirm that that is indeed what they do.
That's correct.
Correct?
There is no
Okay.
fraud verification.
I just wanted to understand that. Thank you.
I agree with that.
Thank you, counsel.
Thank you, Your
Okay.
Honor.
May it please the court, Joseph McLaughlin for the Countrywide respondents.
Counsel, good afternoon. Let me ask you the same question I started with him.
Yes, Your Honor.
How does Nomura now change this case? What, if any, claims do they have remaining?
I will begin with Nomura, Your Honor. Nomura is dispositive of the sole remedy appeal because the First Department correctly applied, even though it did it before Nomura, it correctly applied the exact same contract analysis this court prescribed in Nomura.
I'm going to ask you the same question I asked in Nomura. Can you give me an example of a misrepresentation under 2.01J or K for which Ambac could seek compensatory damages?
Absolutely, Your Honor. If Ambac is able to identify a false statement by Countrywide that is not about defective mortgage loans.
Give me an example.
And I'll give you multiple examples, Your Honor. For example, in Section 2.01K is about the securities laws and the offering documents being in compliance with the securities laws and containing no false statement. those offering documents are subject to a no untrue statement provision, and they contain numerous representations that have nothing to do with the quality and characteristics of mortgage loans. And if you go to page 1828 of the record, there are descriptions of the RMBS certificates. There are over-collateralization provisions, including how excess cash flow will be distributed to certificate holders, and then descriptions of how LIBOR will be calculated. That's at page A1837. Those are just three that come to mind. But keep in mind, Section 2.01L's broad, plain language sole remedy provision also applies across Section 2.01L. So you might also just as fairly ask, is there anything else in Section 2.01 that would not be subject to the sole remedy? And to that, I would answer, as Your Honors, I believe, noted in the, I think you wrote the decision, Your Honor, in Nomura, that the fact that Countrywide is organized under Delaware law and it's in good standing, it has the authority to enter into the transaction. 2.01G speaks of financial statements being prepared in accordance with GAAP, nothing to do with the quality of mortgage loans. So clearly, there is a purpose and non-superfluous
Why would
role.
Ambac challenge any of that unless they ran into a problem with the underlying mortgages?
Well, someday they, you never know what the next case may bring. But the important point here, Your Honor, is
Well, no, the important point is none of that matters unless these loans default and they've got to pay the piper. So it always, right, wasn't that the Nomura view?
Yeah.
That it always traces back to these loans.
That is 100% correct. Here, as in Nomura, it's Ambac's only theory of injury depends on, quote, defective mortgage loans, which this sophisticated party contracted to run through the sole remedy provision.
Nomura, though, it's a breach of contract, and I don't recollect it as having this fraudulent inducement aspect to the complaint.
Different claim, Your Honor.
Right.
Yes.
So does that change the analysis here?
It does not, Your Honor, because as counsel conceded, in exchange for millions of dollars in premium, they issued a irrevocable and non-conditional policy, so they can't seek...
So they can't rescind the contract, but does that mean that they've also waived their right to a measure of rescission-type damages?
Absolutely, Your Honor. That's what the First Department held here, that they've done, and every single court in the nation that's considered that question.
Can I ask just a follow-up on that question as you're answering it? I'm a little confused on the compensatory damages discussion and rescissory and, the payments made under the contract. That, assume, just for this purpose, that we accept that the repurchase protocol is the remedy for the contract violations.
Yes.
On the tort claim, damages then would be compensatory, and that's where this compensatory analysis comes in?
Your Honor, they are compensatory in name and label only. What's going on here, and the First Department was square on in putting its finger on this, is that what Ambac is doing is that by doing away with loss causation, Ambac wants to turn a common law fraud claim into the rescission remedy it knowingly gave up.
I understand the point they made. My question, though, is so there is some measure of compensatory damages that wouldn't be tied to the repurchase protocol, nor would it be all the payments, $2 billion or whatever they've made under the contract, that would be available to them under the tort claim?
The appropriate measure of damages for the tort claim is that which this court has prescribed for decades and decades, which is the out-of-pocket loss standard. That's not what they're going for here.
And what would that be here?
Here, it would be damages that are attributable, as this court said in the Reno case like 100 years ago, that indemnity for the actual pecuniary loss as a direct result of the wrong. So they have to identify non-conforming loans that breached a specific covenant in a fraudulent manner, and then they would have to have an expert come in and calculate what the damages are. But what they're doing here, Your Honor, and this is the key point, they want to throw causation aside and change the bargain they made and have Countrywide pay for every loss on every mortgage in 17 securitizations, including mortgages that conformed in every way to the reps and warranties and defaulted for reasons having nothing to do with any alleged...
They say they never would have entered this arrangement. They would never have issued the policy.
That's, Your Honor, that's the key difference. That's but-for causation. That is not proximate causation. This Court has forever noted the difference between, we're all here, Your Honor, for example, because we passed the bar exam. That's but-for causation. If we had not, we wouldn't be here. But this Court has said boundaries are appropriate when it comes to damages, when it comes to fraud. We're not just going to have this, you know, oh, it could have been, it all started here and a snowball effect. No, as the First Department correctly cited Your Honor's decisions, saying it has to be a direct result. As this Court has said over years, time and time again, you have to show a direct, immediate, and proximate causal connection between the misstatement and the loss.
Well, if that's not direct, if that's too much but for, what about my question regarding the premiums? Or do you think that's a red herring? That's really not something that we should think about?
I don't think the premiums, I mean, it's something
I mean,
that...
you've argued that
was
a
part of
lot
the
of premiums were paid, so they've done very nicely. I understand that argument.
Sure.
Right? My question was whether or not one can really ever say that they would not have issued even this monoline policy because they would have just requested a lot higher premium to back this
It's
up.
possible, but they have, you know, I'm happy to agree with my contrary counsel when I can, and we do agree that because these policies are irrevocable and unconditional, they cannot walk away from them.
So what about the cumulative remedies clause in section 502B of the indemnification?
Yeah, Your Honor, I'd call it Nomura plus. This Court in Nomura said that a catch-all cumulative remedy is a general provision and it was not intended to displace a more specific provision. But we have a better provision, frankly, and I thank the people who drafted it. Our provision, unlike Nomura, says it stipulates that remedies are cumulative and you can go outside, you can get all the remedies in the bucket, unless expressly provided otherwise. Here, the repurchase protocol in 2.01L expressly otherwise provides. It's a specific carve-out from section 5.02B's generic preservation of other remedies.
Can I go back for a moment to the fraud claims, the fraudulent inducement claims? I just want to be clear on one thing. There is a long body of law regarding, you know, fire and property insurance and that sort of thing, that says that it's not necessary for the insurer to prove justifiable reliance.
I'm glad Your Honor brought that up.
You're not saying that we should change that body of law?
No.
Are you?
The legislature certainly has not seen fit here to relieve insurers of proving justifiable reliance and loss causation. Their position is misguided to the core. Rescission is a remedy for misrepresentation under the law of contract, not tort. That's in a restatement level point of black letter law. Rescission, a contract remedy, has never altered the elements of a common law tort claim. This Court in American Surety that Your Honors discussed a moment ago specifically pointed out that courts in equity and courts in law evaluate fraudulent statements under different rules. So cases addressing rescission, like the Ginsburg case he mentioned, American Surety, aren't relevant for two reasons. Number one, Ambac is seeking damages at common law. It's not asserting and admits it can't seek rescission. And number two, it issued irrevocable policies and a financial guarantee. They have not cited a single case anywhere in the world that relieved an insurer alleging common law fraud from having to show justifiable reliance or causation. Its cases all involve insurers proceeding in equity, seeking rescission, returning the premium that they were allowed to and did and get people back to square one, status quo ante. It's basic equity law. Our legislature hasn't made a decision to do that. I see that I'm now a tenant in sufferance, Your Honor, so if I may conclude, I'd like to do that, but if Your Honor...
A generous reading of the red light, but okay. I'll record your tenant in sufferance. Go ahead, close up quickly, please.
Your Honors, in Ambac's world, a sophisticated monoline insurer can ignore known risk factors and conduct no due diligence, collect tens of millions in premium, and then, if the securities can perform poorly, it can comb through prospectus supplements years after the transaction and assert a misstatement. Even if Ambac didn't read it, let alone rely on it, and even if that misstatement had nothing to do with why Ambac made payments under its irrevocable policies. Yet in Ambac's world, Ambac should nevertheless
But in
prevail.
Ambac's world, he's trying to disincentivize your fraud. And doesn't your rule incentivize your fraud?
No, the
Or alleged fraud, not your
Alleged
fraud or your
yes, Your Honor.
client's fraud.
Thank you for that clarification. I would say that this court has already struck precisely the right balance. The common law already provides that a plaintiff who's taken reasonable steps to protect itself against deception won't be summarily out of court merely because, in hindsight, maybe it could have done better.
So why
Ambac's
isn't it reasonable to say, you have to warrant to me a set of facts that I will treat as true, and if it turns out that you lied, then I'm no longer going to pay?
Because that would be rescission, Your Honor. We would be back to square one.
Well-
Ambac's discomfort at having to explain to a trier of fact its decision not to fly blind in the face of clear risk isn't a valid reason to create a new insurer-only rule that the legislature has declined to create.
Thank you,
Thank you, Your
counsel.
Honors.
Your Honors, if I may, what Ambac seeks is the same rule to be applied to financial guarantee insurers as to all other insurers. The fact that the insurance is irrevocable does not change the risk allocation between the applicant and the insurer. The applicant has the same duty of candor, the same incentive to lie, the same asymmetry of information of greater knowledge, and the insurer.
It seems like what you're calling damages really is the rescission that you contracted away.
Well, again, that's not right, Your Honor. What Ambac agreed to do was to continue to perform for the benefit of the innocent beneficiaries, like pension funds, retirement funds, the RMBS holders.
Okay, so-
Ambac never agreed to waive its rights against Countrywide, the guilty and dishonest applicant.
That may be, but doesn't that put you into the common law fraud realm?
Well, yes, Your Honor, but it's insurance common law fraud, and specifically, it's the ability to assert the same
We're
duties.
sort of going circular, because
Well,
I think insurance common law fraud really talks about rescission, so.
Well, but again, that's because typically an insurer is trying to avoid performance or to rescind. In this context, it's different. The insurer is performing.
I have a particular
Yes.
problem for me that I don't think applies to the rest of the bench, which is, and this relates to what Judge Stein was just talking to you about, how can I get to your position without disagreeing with myself in the First Department decision in MBIA versus Countrywide, where we said that when I was on the First Department, that because it was non-cancelable, you can't get rescissory damages.
We're not seeking rescissory damages. We're seeking compensation for amounts already paid. So we're performing on the contract. It is not a rescission. And in fact, Ambac continues to
I
perform.
know you're not seeking a rescission, but aren't you really seeking some measure of rescissory damages?
No, we're seeking compensation for the wrongfully induced performance. In other words, for the dollars that are paid out by Ambac to the innocent beneficiaries. Countrywide, in effect, is the indemnitor for that, since it's the
But how
dishonest
doesn't that
applicant.
end up putting you in the same place you would be as an insurer who's arguing for rescission? Aren't you both on same footing?
The
And
same-
seeking to be placed exactly in the same position by the relief you're requesting?
No, Your Honor, because unlike the insurer that seeks rescission, Ambac continues to protect the innocent beneficiaries.
Yes,
as
I
in
understand. You're not,
the auto
I understand. You're not
context.
seeking,
The
in that
quantum of
sense, avoidance
damages-
of the transaction or the contract.
I
I get
agree.
that. But all you seem to be doing is saying, yes, 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 the insurance policy stands, but we're not going to pay for it. They've got to pay for it.
Oh, we
So
are
in that
paying for
sense, aren't you being put exactly in the place
We are
of
paying
someone
for
who
it.
seeks rescission?
The quantum of damages may be the same, but we are paying for it. And indeed, that follows from the fact.
And how does that impact you differently? Help me here, understand that.
Because, well, Ambac, in fact, the parent company went bankrupt as a result of the liabilities of performing. It was a terrific loss for the company. The idea that there is a windfall to Ambac is preposterous. In fact, what Ambac is trying to enforce are the same rights, holding the dishonest applicant accountable in the same way for the statements which are made, since those are factual warranties. And I wanted to highlight, Countrywide itself conceded, when we look at these warranties, they conceded that if Ambac asserted claims about the broader Countrywide operations, that would be not remediable by this loan-level repurchase protocol. That's at page 47 of their opposition brief. And it's the same with the securities compliance warranties. They can't fix that through the repurchase protocol, and that's because this 2.01L set of RMBS rights was never intended to fix the problems relating to the far broader insurance warranties. That's why we're seeking to use the insurance remedies, and it's not just a matter of 502B, the cumulative remedies provision, which is not within a grant of securities interest. It's an independent provision. Article 5 itself on defaults and remedies has no analog to what's in Nomura. If we look at 502A, though, it's very plain. The insurer gets all of the rights at law and at equity, both under the contract and separately.
Okay,
And that's,
thank you,
thank you,
counsel.
thank you,
Thank
Your
you,
Honor.
counsel.